The following is a paid program. Advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome in, everybody, to Taking Care of Business. And this week, of course, in this show, we're featuring Rob Melick with Melick Law. Good morning, Rob.
Good morning.
We'll start off with me asking you a question about something I know that you love, and that's the Brewers.
Yeah, well, all good things have to come to an end. So it was an unfortunate loss yesterday, but I mean, when you win 14 in a row, you're due for a little regression. I think that's fair and expected at that point, but it's been an incredible run, and hope it continues. Doubleheader today against the Cubs, so that's another big one. So at least got to split that one, and because you split, you stay at 8 up, so that's a really big thing there, and it's 5 games in Chicago. So hypothetically, if they take all 5, that 8-game lead goes to 3. So if you take 2 or 3, it extends to 9 or falls to 7, and the season is just on our side at this point as far as timing and everything else. So let's see how it goes, but let's enjoy the ride while we can.
Do you have a prediction for this 5-game series? What do you think?
I think the Cubs are going to take 3 out of 5.
That's
my prediction. I hate to say it.
That home field, Wrigley Field.
Home field, it's in Chicago. The Cubs have a good team, let's face it. I mean, I know as Brewer fans, we all like to hate the Cubs, but let's call a spade a spade. They're a very good team. I think they split today, and then the Cubs take 2 out of the next 3. But I hope I'm wrong. I hope that flips. We'll see.
All right. Well, you heard it here first. We'll see what happens. But, of course, we're not here to talk about baseball. We're here to talk about the awesome service that you provide with Melick Law. Last show we had with your crew, we actually brought in your 3 paralegals on your team who did an excellent job of not only talking about how great you are at what you do, but talking about some of the work that goes on behind the scenes that makes things happen, because you're not a one-man show.
Not at all. No, I couldn't do it without my paralegals. So I'm glad they took over the show for me. I was just coming back from my cruise at that point. So I had a whole bunch of appointments stacked up that day. So fortunately, they were able to take it, and they enjoy it too. I mean, a day out of the office is a day out of the office. But they did. I did listen to the show after the fact. I pulled it up, and they did a wonderful job. I expected nothing less, but took a couple good-natured ribs at their boss, which is wonderful. I have no problem with that at all. But no, it was good to have them on. I'm grateful that you guys gave them that opportunity, and that they were able to do such a good job, not only explaining about Melick Law, but also a little bit about themselves too. The paths they took, where they're at now, why they enjoy doing what they're doing. So it was all in all a good experience. I thought all 3 of them did a very good job.
And it was a nice testament to the atmosphere there at the office. And they talk about how much they enjoy working there and enjoy doing the work. They always say, if you love what you do, you never work a day in your life, right?
That's right.
And then they talked about at the time they're prepping for a span you guys are going to be spending at the Washington County Fair. So you guys are out there for the span of that. How'd that go for you?
It went really well. It's one of those things where I can remember when I started at my old firm here in Wisconsin, we wanted to give it a shot, and it went well. And first couple of years when I had my own firm, it didn't fit in the schedule. I was a one-man show at that point in time, when I first started and everything, and just didn't have the time for it. But this is our 3rd straight year doing it. And we get a lot of clients out of it. We've had a lot of calls, a lot of appointments, a lot of people sign up. So it's a very profitable thing. And I also had the opportunity to be on the air with Wade during that. You guys were out at the Washington County Fair.
Sorry now.
Yeah, no, it's all right. It was wonderful. Yeah, Sierra had texted me that you guys were there, and I found your booth, and Wade and I recorded a couple segments. It was like a 2-minute segment and like a 90 second segment. So it was good to see them out at the fair. And I mean, I enjoy being out there talking to people in that kind of situation, and also the amazing food, by the way.
Right.
That's always a plus at the fair. But and my older son was able to go out there for the fair. He took one of his buddies on the unlimited ride night. So
nice.
You pay $30, you get a wristband, and you ride rides all night. So they took every advantage of that they could. So I'm from Washington County, so I have memories going there as a child when it was in Slinger, and now they moved it up to Polk there, Jackson area. So it's good. I didn't get a chance to make it out to the Dodge County Fair this year, though. I've been out there a couple times. I think it's been about 3 or 4 years since I've been out there, but that's also a nice fair. The difference is they put the vendors outside and then that one non-air conditioned area.
Yeah.
So that was tough. But the Washington County Fair has this great air-conditioned venue.
Yeah,
where
that
I
big
can
commercial building. It's massive.
You bet. So I'm a fan of that. It gets over 75, I start melting a little bit, if I'm being honest. So it's nice to be in the air conditioning for sure.
I can definitely agree with that. There was some days where it was very warm out at the Dodge County Fair. And then, of course, the days where it was very wet, Saturday specifically.
You bet.
But, no, it's great seeing you out there. And it's nice because for a lot of people, when it comes to thinking about estate planning, it's not something people just sit around at home and go, we should really think of. It's usually in the moment, in passing, and then it's okay. Get as much information as I can right now, and then if I remember, I'll come back and revisit this.
Right. It's not what I call a sudden moment event always. Now, sometimes it is. Sometimes it's, somebody in their family passed away, someone in their church passed away, and they realize how much of a mess it is, and they realize they need to have an estate plan. But I'd say that's the minority of my clients. The majority of my clients kind of have it on their radar, so to speak, and then they get around to it when they get around to it. So having a presence at a fair is just another touch point. It's another opportunity to get in front of people and say, hey, gee, this thing you guys have been thinking about for a couple of years, you're not getting any younger. I mean, everyone who's alive now, by definition, assuming you're over 5, was 5 years younger 5 years ago, right? So that's the idea. As time goes on, we all age every single day. And again, most people know, hey, this is a good thing to do, but most people think, I'll get to it tomorrow. Well, with all due respect, eventually there's going to be no more tomorrows.
Right.
We just know when those tomorrows expire. So creating an estate plan and having that peace of mind for as long as possible is a really good thing. And, again, it's just other areas of practice are different. I mean, if somebody were, arrested for a crime, well, of course you'd seek out a criminal defense attorney right at that point because it's urgent. If you're in a car accident, personal injury case, if you're getting divorced, all these other areas of law are reactive. It's the idea of an impetus occurs that may or may not ever occur, right? Not all of us are going to get arrested for a crime. Not all of us are going to be going through a divorce or have a personal injury. Whereas estate planning, every single person is going to pass away. 100% mortality rate in the human race. Unless and until that changes, everyone's going to need an estate plan. It's just a matter of, are you going to plan appropriately before the inevitable occurs?
And it sounds bleak, but in all reality, it's pure factual numbers.
Yeah.
I mean, it's the harsh reality of it.
You bet. And it's one of those things where, any rational, sane adult is going to know that they are not immortal, that we're all going to pass away at some point. Now, different people have different perspectives on their relative mortality in terms of when they're going to pass away. I call it the ostrich burying its head in the sand type approach. Right. Yeah, it'll happen. That's a long, long time from now. I'm 20, I'm 30, I'm 40, I'm 50. That'll happen when I'm 70, 80. Maybe we have longevity in the family, 90. Well, car accidents happen every day. Fatal car accidents happen every single day. And again, you don't know when it's going to occur, but it will occur. So my advice to people, again, is why not have that peace of mind for as long as possible? Why not lock in your estate planning costs now? Because just like everything else, things just get more expensive over time. So why not lock it in now for that event has a 100% chance of occurring? And at Melick Law, that's what we do. And if life events do change, some people might say, well, I don't know my current situation. I don't have grandchildren yet. If I have them down the road, well, that's great. I hope you do have grandchildren down the road. I hope to have grandchildren down the road, right? But at my firm, not only can you make those changes, I do so on a complimentary basis for my existing clients. So having the thought process of, I'll wait until my life plan is set, at my firm really isn't a good excuse because you can always adjust it down the road. And again, it's done for free at my firm.
Now, that leads me into a question we actually had from after the last time we had you physically on the show. Somebody actually texted in, we missed it before the show ended. But they said, hey, I have a question about a trust. Mm-hmm. If you revise a 15-year-old existing trust document that you had created for their family, does that reset a look-back period?
It depends on the nature of the trust. So a look-back period only applies to irrevocable trusts. Revocable trusts do not have look-back periods. So it's irrelevant. So I would need more information to answer that question. I suspect by virtue of how the question is asked that they're referring to an irrevocable trust. Otherwise, they probably would not have put the look-back period in. And unfortunately, irrevocable trusts cannot be revised. You are irrevocably conveying the term, and that's one of the downsides of an irrevocable trust. So again, if that person is listening and wants to provide more context, I'd be happy to answer it further. But if it's revocable, so I guess the answer is that wouldn't happen because if it's revocable, there is no look-back period. You can amend it however you want. Right. If it's irrevocable, on the other hand, then you do not possess the ability to change it because by definition it's irrevocable. So I'm not sure which one it is.
Now, what is the look-back? What does that mean?
Yeah, so the look-back period relates to the attempt, and I really do emphasize the word attempt, of trying to avoid nursing home estate recovery. The idea is people will create irrevocable trusts in an attempt to have certain assets not be counted or not have to be liquidated in the event that their spouse needs the government to pay for their nursing home care. So the government obviously does not like people doing this, right? So one of the ways they discourage it is they have to make it irrevocable, that we as the creators do not have the ability to make those changes, just as a way to disincentivize disincentivize people from making those changes. So that's what you're looking at there. And again, most of my clients prefer the flexibility. They want to be able to make changes to the documents. That's why they normally will create revocable trusts, despite the fact that it does not provide protection from nursing home estate recovery. It gives you the ability to make those changes, gives you full use, full access, full control, whereas an irrevocable trust does not do that.
Okay, that's good to know. Yeah. And if you have a question that you want to ask Rob, feel free. You can give us a call here at 920-885-4446, or you can call or text us at 920-887-9595. We do have Jeff up in the studio. He'll be more than happy to convey those calls down or convey those texts down to us if you have one. If you'd feel more comfortable reaching out to Rob and his team, unless this number's changed, 262-347-3444. And you have multiple locations that you can meet with people.
I do. My main office is in Saukville, but for most people listening or viewing this, Beaver Dam is probably my most proximate location. Sandy and Matt generously let me use their office to meet with clients, so I can meet with them over at Hire. But as I mentioned, I do also have my main office in Saukville, as well as satellite offices in Germantown and West Bend. I do offer free initial consultations to anybody, so that's not just a perk of listening to this radio program. I always offer free initial consultations. And aside from those 4 offices, I'm willing to meet in your home. Perhaps you have mobility issues. Perhaps you don't want to pay for a babysitter. Just throw the kids in front of a movie and you can meet with me. And I do also offer virtual meetings, Zoom, telephone, whatever the case is for that initial consultation. However, I do also offer a 20% discount for WBEV listeners as well as dailydodge.com viewers. So if you do decide to give me a call, mention that you heard me there or saw me there, and I'll happily take 20% off the bill. The other thing I will say is this, is that when it comes to estate planning, kind of like the question implicated, people come to me in one of 2 ways. They either are starting from scratch and or they know they need to revise the documents, or people have existing documents that they're unsure of the applicability. So even if you have existing documents, at no charge, I will review those documents and I will do what I call telling the story of your estate plan. And what I do when that occurs is my prospective clients will come in with a set of documents that probably another attorney prepared, maybe they got them online, whatever the case is. And I always tell my clients, okay, I'm going to tell the story of your estate plan. Stop me where you don't like what I'm saying. If there's ever a point where you don't like what I'm saying, let's pause and let's figure out how you'd want it revised. And that allows the clients to be able to say, well, gee, I didn't know that we had, Billy on there. Well, Billy passed away 5 years ago. Or, we had our college friend on there. Well, that college friend and I haven't talked in 10 years. We need to replace it. So again, whether you're in the situation of starting from scratch or looking to get advice on an existing document, free initial consultation. And again, the number for any of my offices is 262-347-3444. Again, 262-347-3444.
Now, I want to ask you about, and this was an argument I heard recently at a family event where they were talking about things like life insurance and Social Security, and then what's going to happen? I have a will, I have this, I have whatever. And somebody said, well, I'm not doing any trust-based thing because my plan is really simple. Everything goes to X person. And it's so simple that there's no reason to go through all that.
Right.
Meanwhile, somebody else said, well, no, I need something like that because I've got, 6 kids, I've got 14 grandchildren, I've got a brother who's still alive, I have all this stuff that I want to, disseminate out to all of them, and it's so complicated, I need a legal document.
Right.
My understanding from our conversations with you is whether complicated or simple, you still need to have something.
Right, because I think the people who are saying it's simple, they don't need estate planning, are only looking at half the equation. Okay, so when it comes to estate planning in general, I always divide the discussion into 2 parts. Part 1 is who is going to get the assets. Part 2 is how are they going to get the assets. So I'll give you an example. Let's just take a garden variety situation, husband, wife, 2 adult children. Okay, if they don't create an estate plan, they'd say, we know it's going to be divided among the 2 kids. Okay. Right. Will it eventually get divided between the 2 kids? Yeah, it will. It's not like some interloper is going to come in and change that. Right. So part 1 of that equation is met, but part 2 is not, because if that couple has more than $50,000 worth of probate assets, in order to get it to the children, it has to go through probate. That's the downside. It's not just who is going to get the money, because they're right. It will event. Wisconsin has what's called intestacy laws, which in English means laws that determine asset distribution if somebody passes away without a will or a trust. Right. And the intestacy designations will say go to surviving spouse first, and then to surviving children or the children of deceased children in equal parts. So the idea is, yeah, it'll get there, but it's going to have to go through probate to get there if it's more than $50K. So if that family owns a home and they've done no sort of estate planning whatsoever, if the equity in that home alone exceeds $50,000, right, it's going to probate. Now, a lot of people will say, well, I have money in a safe. What the government doesn't know, they don't know. Well, I have two comments. That one is, sure, if that may be the case, but in order for you to successfully close out an estate, your loved ones have to sign an affidavit saying, upon information and belief, and with penalty of perjury, this is worth less than $50K. Are you going to have your beneficiaries potentially commit perjury? Maybe, maybe not. But the other point is, when it comes to real estate, you need a deed to be able to sell the home. Right. You can't just give the home away. They're going to look at it, and any realtor, any company, before they process is going to say, wait a minute, this at home has more than $50,000 worth of equity. We cannot sell this home without a domiciliary letter. A domiciliary letter is what you get from a probate court enabling you to be able to sell it. So if you don't have the domiciliary letter, you can't sell the home. If you can't sell the home, it doesn't matter how simple the estate plan is, because it's not going to get to the beneficiaries. It's going to have to be sold. And the only way, again, to sell it is to go through probate if you don't have a trust in place, or if you have only a will and you have more than $50,000 in probate assets. Now, if that same person who has simple stuff says, I don't own a home, I rent, and I have beneficiary designations on everything, okay, is that still enough? The answer is maybe. Because people say that to me all the time, well, I have beneficiaries on everything. First of all, you can't possibly have beneficiaries on everything, because there's a large swath of assets that we can't do that for. Vehicles, jewelry, appliances, tools, furniture. It's not possible to list a beneficiary on those. And then the other beneficiaries, we have to assume, in order to avoid probate, that the beneficiaries will survive. And that's not a guarantee. That's the example I always give. I have two boys who are 15 and 12. By definition, they're a generation younger than me. Statistically speaking, they should both survive me. Right. But that's not a guarantee. Right. In fact, we will not know the answer to that question until the day I pass away. That's why I'm such a big fan of trust-based planning, because the trust is a guarantee. I always tell my clients, there is not a human being on this planet that has a 100% chance of surviving you. Right. It might be 99.9 whatever, but it's not 100. The trust is 100. And the trust, furthermore, allows you to decide where those assets will go if that person or those people predecease you, because not everyone has the same answer, right? The example I use is with my parents, okay? I have a sister, 50-50 distribution between the two of us. Great. What happens if I die first? Well, broadly speaking, the assets could all go to my kids. That's the most common way to do it, but some people don't want that. Some people would say they would want it all going to my sister at that point. You can't specify that if you don't have an estate plan. Right. It has to be determined at that level. So again, it's the question of, are we willing to take the risk that the beneficiary designations are going to be sufficient, and do we not have other assets to make it such that it's over $50K, in which case, yeah, the distribution may be simple, but even simple distributions go through probate. There's no law that says, well, if you just have two kids, we avoid probate. It doesn't work that way. It's black and white. Right. They're either more than or less than $50,000 in probate assets. If it's more than $50,000, it goes to probate. And again, negatives of probate: one, average cost, $8,000 to $12,000. Second, timing, average length of probate, 12 to 18 months. Third, it all becomes public record at that point. There may be some predators out there, bad people who are going to see these people are receiving money, especially if you have younger beneficiaries. Mm-hmm. And that could be a significant problem. So again, my thing is this: we want certainty. The only certain outcome is to create a trust. Anything short of a trust, we may avoid probate, we may not. So again, two-part analysis. Who gets the money? How are they going to get the money? When you have a simple situation, those people are going to get the money, but they're not going to be able to do so typically without going to probate, assuming the value of the probate assets is greater than $50,000.
And something I think I've had kind of impressed upon me as I've gotten older, and I've obviously you have more and more older relatives passing, is I've yet to come across a situation where the divvying out of assets was ever truly simple. Right. It's everything from, 6 months before they knew they were going to the nursing home, and 8 months before they passed, they had people come over and put stickers on everything for what they wanted. Right. It's like, well, that's great, but what legal ramifications does a sticker have?
The answer is none.
Right.
I always tell my clients when you do things like stickers or lists, if you do it without the benefit of an attorney, you are creating a moral obligation, not a legal obligation. Now, what I will say is this: in most families, moral obligations work.
Right.
In most families, in most situations, moral obligations are just fine. The problem is that we don't know which situation is going to occur in which family. So if you have any sort of doubt whatsoever, make it legal. Because if we put in the documents that Junior gets the refrigerator and Jane gets the couches, then that will govern. That is a legal document. Whereas if you put stickers on the bottom of them, who's to say that they're going to agree when the stickers were put on? Who's to say someone didn't come into the house a week before and swap the stickers around? I mean, there's any number of issues that come into play with that. But by making it a legal document, you are able to guarantee that your wishes will come to fruition with the power of the ability for someone to bring a lawsuit if they don't.
I want to take a moment as we're reaching the bottom of the hour to remind everybody this is a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Another nice thing that we've talked about is it does kind of allow you, when you have a trust-based planning, to kind of build in some contingencies. You can have, if-then kind of statements. So, I want the house sold and the proceeds divvied out to my two children unless one of them wants to purchase the home.
Right.
And then they buy it from the other one, stuff like that.
Yeah, and you could put in what they call rights of first refusal, right? And a lot of times most people do it by age, not always, but they'll say exactly what you just said. And then the next question is we have to determine what that value is. Do we have an appraisal? Do we go off the tax assessed value? Does the client just indicate a dollar figure saying they have the right to purchase the home for X dollars, regardless of what the actual value might be? But again, we do so in a way that is not mandatory. We're not forcing a child to buy out the other one's interest, but we give them the right of first refusal to be able to make a decision as to whether they do or don't or can or won't do it, right? Because it's really a two-part issue there, right? You could have the motivation, but you have to have the ability, I want to be a jockey. Well, I'm 6'2", 270. That ship sailed, right? I mean, I can want it all I want, but it's just not going to happen, So it's kind of the same idea there, is to make sure that we have the desire and the ability to be able to take advantage of that. And if we don't, well, the remedy's simple. We just split the proceeds. So it's it's kind of a foolproof way to do it, because either they're buying it out or it's just going to be sold.
Right. I had a question about probate because I'd heard somebody talking recently about how their grandfather had passed. About 3 years before he died. He had bought himself a nice new, it was a Dodge Charger. And that was his fun car. That was his late in life car. And in his will, trust, whatever, he had agreed to leave it to one of the grandkids.
Sure.
Or I'm guessing it was a will because it's still going to probate from the conversation I'm hearing.
Yep.
And so there's still money owed on that vehicle.
Yes.
Payments are still need to be made on that vehicle.
Sure.
And so the person who's getting it's like, well, I don't take ownership of the car until after it goes through probate.
Correct.
But payments still need to be made.
That's right.
Yeah. How does all that work?
Yeah, so typically what happens is this. We open up the probate matter as quickly as we can so that the estate can pay for that. In other words, this person probably had bank accounts, probably had retirement accounts, things like that. Those get liquidated to the estate, and the estate can continue to make those payments. If that's not feasible, then what typically will happen is a personal representative will continue to make those payments and then get reimbursed on the back end. The idea is if we stop making payments, that's a problem, right? But it is the estate's responsibility to continue to make those payments. Now, the other problem there is if it does go to Junior, Junior is benefiting from the estate making all those payments. So typically that gets reduced from the share Junior would otherwise receive. In other words, you have this charge that's worth 60 grand. I don't know anything about Dodge Chargers, but let's just say it's worth 60 grand and there's a lien on it for 35. Well, the value of the asset is 25,000. At that point, right? So typically what will happen is if it goes to Junior through a will, you would specify, okay, these payments are coming either out of Junior's other share, but now if Junior isn't receiving anything else, then it would just be money that would have to be paid back into the estate at that point in time.
Which, again, shows the complicated nature of stuff, and especially if it's got to go through probate.
And especially if there's a lien on it, right? I mean, if it's owned outright, that's one thing. I mean, you just go through the procedural channels of getting the deed, the title changed, and that's relatively straightforward. I mean, the DMV does make it somewhat difficult, but it's manageable. I mean, I can tell you I've given hundreds of clients the advice on how to do it, and I've never heard back from one client saying, nope, it didn't work. So it's relatively straightforward there, but when there's a lien, that's what becomes a problem. Or when mortgage is owed on a house, right? I mean, got to make sure that mortgage is paid, got to make sure the taxes and the insurance are paid, because if you don't, don't, and the house goes into foreclosure, now you got a big problem on your hands. Right. So that's one of the obligations of the person representative, the executor or the trustee, is to make sure that those are paid. Now, they don't have to pay those out of pocket. They can use estate or trust proceeds to be able to pay for them. But then there's that question of equity, right? If somebody's getting that home or that vehicle or that possession that's otherwise owed money on, they should be the one bearing the incidence of those payments because they're the one who's going to benefit from it. Because if they had it right away without the benefit of having to go through, or without the misfortune of having to go through probate, they'd be responsible for those payments. Because the other remedy is they could just say, nope, I'm just going to sell it. Right. Sell it and get whatever you net from it. 60 grand car, $35,000 lien. Walk away with 25 grand. That's another remedy.
Now, when we talk about probate taking 12 to 18 months, when we talk about a trust that we've talked about how that outlives you as the decedent.
Correct.
So, how long of a wait after does that kick in and start doing what it needs to do?
Yeah. So the short answer is it depends, and I'll give you two examples just by way of contrast. Okay, my parents both pass away tomorrow. It's my sister and I. We're both in our 40s. It'll be very easy. Now they own real estate. So I can't tell you how long a parcel of real estate is going to take to sell.
Right.
It's a hot market right now. It's a seller's market right now. But when that happens, who knows what it's going to be. So that's a variable. Right. Real estate is typically the biggest variable because, again, depending on the nature of the real estate, depending on the market, depending on any number of variables, that's not easily liquidatable, right? I mean, you have to have a closing. You have to go through inspections. You have to get a realtor typically, whatever the case is. But that should be relatively quick. Compare and contrast that to my own personal situation. My wife and I die tomorrow. We have two boys who are 15 and 12. Right. Our trust says they don't get full access to that money until they're 30. That trust could live a long, long time at that point, right? So it's not really a one-size-fits-all answer. I'd argue, though, that it's always going to be as short or shorter than going through probate. Right. Because if we had a will, we'd be in that same situation. Except we'd be paying 8 to 12 grand to get there.
How long can a trust last?
Until there's no more money left in the trust. So that's the thing. Again, going back to this example, and this is not the case. Bear with me. I'm just using this hypothetical. Let's say my wife and I had a net worth of $50 million. Okay, $25 million each kid. It's going to take a long time for them to spend $25 million.
I'd hope so.
Right? I hope so too. But let's say we had $500,000 worth of net worth. Well, that's $250 a kid. That's going to last a lot less than the $50 million example. So that's really the question of how long it's going to last. How old are the beneficiaries? Because at 15 and 12, they're close to adulthood. They're closer to 30 than they would be if they're 5 and 2. So there's a lot of variables that go into determining how long the trust is going to last.
Now, the trust money. So let's go with the lesser amount. Let's say you go with the $250,000 each kid.
Yeah.
That money is just sitting there doing nothing. It's not working for you, working against you until it's all gone, and then it's gone.
That's not necessarily true. What would happen is the trustee would invest that in an account that he or she would deem appropriate. So think of it as buckets, right? If we have $500,000, $250,000 gets poured in the Grady bucket, $250,000 gets poured into the Hudson bucket, okay? As time goes on, maybe one of them dips into the bucket more quickly than the other one. One example would be, let's say one goes to state school and the other one goes to a private school, right? The one who's going to the state school is going to have his bucket deplete much less quickly than the one who's going to private school. Right. One needs braces, one doesn't. One gets a nicer car than the other one. There's any number of variables that will contribute to it, but while it's in those buckets, it can certainly be invested in the name of the trust in an investment that makes sense. It doesn't need to just sit there in a checking account getting next to nothing. Right. Put in a money market account, put in CDs, but that is the trustee's discretion. The trustee has the discretion to say where that money is going, and just so long as he or she is acting as a fiduciary in the best interest of the beneficiaries, they're fine.
Who determines who the trustee is?
Your documents determine who the trustee is. So if I were to create, my wife and I have a list of trustees that we have. When the second of us pass away, here is trustee 1, here is trustee 2. The documents specify that. And then there's also provisions that say if trustee 1 is unwilling or unable to serve, because maybe trustee 1 was in the car with us when we died. I don't know. There's any number of variables, but then we can specify who the next person in charge is. In the unlikely event that all the trustees predecease, then somebody on behalf of the children could appoint a trustee for the trust. You just go to court and petition the court to say, the guardians are now going to be the trustees of this trust because mom and dad both passed away and because trustee 1 is no longer alive and trustee 2 wants nothing to do do with it. Whatever the case is, there's always a remedy to make sure that there is a trustee appointed.
We talked a little bit when we mentioned the question that was in about revisions. Obviously, with the joy of family, sometimes you love your brother, your sister, whatever, and then you have a falling out or whatever.
Yep.
And it's like, well, they were the person who was going to be responsible for watching my kids. Now I don't want them to.
Right.
Or whatever the case may be. These are all things that are fairly easy to change.
Absolutely. And again, in my firm, there's no charge for that. So the problem is I'm not going to know that. Right. I need to rely on my clients to tell me, hey, we had this falling out. Hey, we have this new person in. We just had a grandchild. We want to make sure he or she is directly included. Those types of things. So when a client proposes that, then the next thing we have to decide is how are we going to make that change? Most of the time it requires a redrafting of the documents, but sometimes we can get away with a one-page amendment. Everything in the trust is exactly the same except where we had brother, now we're going to have sister, whatever the case is. So it just depends on the nature of the change. But no matter what the nature of the change is, no charge for revisions. Now, the only exception that would be new real estate. Because to me, that's not a revision. That's not a change. That's new acquisition of property. So I do reserve the right to charge a fee for that. But as far as revising the documents, who's in charge, who's getting money, those types of things, those are done on a complimentary basis at my firm.
Now, how specific or vague can you be? Like if I'm leaving stuff to my hypothetical, even though they're non-existent at this point in time, grandchildren, and I have 8 of them.
Yep.
Can I just say, and to all of my grandchildren?
Yeah.
Or do I have to name them
No,
individually?
unless you want to discriminate among your grandchildren. In other words, you would just say split evenly between all surviving grandchildren. Now, if you end up having a grandchild who becomes estranged or is someone you don't want to provide for whatever reason, then you'd have to specify it.
So all my grandchildren, excluding Tom.
Right, exactly. Right. Or you want to give more to a certain, maybe a certain grandchild has, more difficulties or comes from a situation where they have less money. I've seen people say, okay, I'm going to do a double share to Jane, but I'm going to do a single share to everybody else. You can do that.
Now, along those lines, there's sometimes and I know this from personal experience, where I've seen a little bit of infighting because it was all right, we got 4 kids and we're dividing it up, and so-and-so's getting 35%, so-and-so's getting 35%, and these guys are getting less.
Right.
And it's, there's arguments and there's fighting and there's, whatever. Well, that's not fair. That's not what I was told. And it becomes this, when it's a trust, how much pushback can people put on that?
So a couple things there. First of all, I always tell my clients there is no such thing as birthright. That just doesn't exist. Just because you're a child does not guarantee you an equal share. People disinherit children all the time. Now, I can understand how that would lead to some hard feelings. I get that. But what I do is I put what I call a no contest provision into my trust. And that no contest provision basically says if anybody contests this, whether they're successful or unsuccessful, they get $1 and nothing more. So that disincentivizes people from contesting. Because I always tell my clients, because I'll get that a lot. People say, well, I want this to be contest proof. I don't want anybody to ever challenge it. And I say, I can't stop people from challenging it. I can make them difficult for them to be successful in contesting it. And furthermore, under Wisconsin law, there's only a few ways you can contest it. You can't just say, well, mom liked me more, mom forgot to put me in. Those don't work. You'd have to either prove incompetence of the person who was creating the trust. The person was not in their right state of mind at the time. That requires medical testimony, things like that. But the interesting one is what's called undue influence. Okay, and most people know the meaning of those two words together, but they don't necessarily know the legal understanding. So I've crafted an example to kind of explain that. Okay, and for further disclosures, you'll see where I'm going in a second.
Yeah.
These are not true. This is all hypothetical, what I'm about to say here. But let's just say I went to my parents tomorrow, and I said to them, look, I do a lot more for you than my sister. She's been a leech. She's been and I love my sister. I'm just making this up as a hypothetical. You really should leave 60% to me and only 40% to her. That is influence. That's not undue influence. That's influence. I'm influencing you in making the decision, but it's not undue influence. I'm stating what I believe to be facts or opinions. That's influence, but not undue influence. Undue influence would be if I went to them and said, you will never see your grandkids again unless you give me 60%. Because now you're putting them in a position where they don't really have a meaningful choice, right? They're saying, I have to face one of 2 incredibly awful realities. I'm going to pick the lesser of 2 evils. So the courts will then say, well, wait a minute. That person was not acting of their free will at that point in time, and we will invalidate that estate planning document.
So it sounds almost more akin to like blackmail.
Exactly. No, and that's exactly right. And that's what it is. Blackmail certainly falls within the umbrella of undue influence. Absolutely. So But I use that illustratively to kind of explain the difference between the two. I mean, morally, there might be something wrong with my first statement,
Right.
but it's not legally incorrect because they're just saying, okay, I'm presenting facts and opinions. It's still up to my parents to make a decision, right? The second one, they're kind of forcing their hand at that point in time, and that's what the law does not allow you to do.
That's really good to know. Tying off of some of that a little bit, when you mentioned the clause that you were saying, where it's like if you contest it or whatever, win or lose, you get $1. So does that essentially rewrite? Like, let's say they were supposed to get 50%.
Yeah.
They choose to contest.
Right.
Win or lose.
That's
and now
right.
the 50% becomes $1.
That's right. And what ends up happening is, in my experience, the one who's getting 50% is not going to be the one contesting it. The one who's excluded is going to be the one contesting because they really have nothing to lose at that point in time. Whereas, again, if somebody's getting 50% and they think they ought to get 75%, well, that's a pretty strong stick there. If they contest it, they go back to the $1. So most people, once they realize what's written in the trust, are going to do that. In my experience, it's typically the ones who either get written out of the trust or have a different amount. So what I encourage my clients to do, to the extent that it's practical, because in some situations it's just not practical, would be to explain to their beneficiaries why the difference in treatment. I'll give you an example of that. I had a client who was a widower, had 2 children, and he decided to leave, I don't remember which one it was, child A, 60%, child B, 40%. And I didn't ask him for his explanation because the explanation didn't matter. It's his estate plan. He can do whatever he wants with it. But what he said to me was, he said, well, child 1 got a full 4-year scholarship to college, didn't pay a dime other than incidentals, whereas child 2 went to a private college, ended up getting a master's degree. We spent more during life on child 2, therefore we want to give more to child 1 at death, or I want to give more to child 1 at death. And again, my advice to this person was, tell that to your kids. Explain that, because what happens is when you're deceased and you're not around and they see 60-40, they're left guessing. Did dad not love me as much? Did I do something to offend dad? Whatever the case is. So in that situation, I would explain it to them. And I don't know what this person ended up doing. That's my practical advice for you. But in certain situations where there's estrangements with children, whatever the case is, it's probably not the greatest thing in the world to call them up and say, oh, by the way, I just did we just did our trust and you're getting nothing. It's not practical at that point.
They probably assume they're getting nothing.
Maybe, but again, even if they didn't assume that, I wouldn't advise opening the wound up again by explaining, oh, by the way, we're not getting you anything. So it's a discretionary type thing.
Right. Well, and that's I wrote down the word communication here because that's kind of a big thing. I know a lot of times I hear about, and family members or friends or whatever, grandparents pass, parents pass, and they go, I had no idea that they cared enough about this other family member to give them anything.
Right.
Or I thought they didn't talk to such and such sibling anymore.
Right.
Whatever the case may be. Or they find out, oh, I'm getting something, and I only saw that person 3 times in my entire lifetime.
Right.
Last time I saw them, I was 6 or whatever. Yeah. And so there are times where it's nice and it's important to communicate. And we've talked about things like guardianship of underage children.
Yep.
That's something where you might want to talk to the person.
Absolutely. Well, a couple comments on that. I guess the first comment I would say is, I'm sure you've heard the phrase attorney-client privilege. Okay. Mm-hmm. There is a privilege that allows clients to communicate openly with their attorney without the attorney having the ability to disseminate that information to others without their consent. And that's, I don't know if sacred's the right word, but it's a little shy of sacred, perhaps, right? It's not the same as, parishioner penitent, priest penitent, whatever that case is, right? But it's an important relationship. We encourage people to have candor. My opinion on that, though, is that to the extent the client is comfortable, I'm a fan of family meetings. Right. I'm a fan of getting everyone on board because it's going to create less issues down the road, because what are you doing? You're communicating. And you're doing so in a manner where the attorney is the one leading the ship, explaining, look, these are my clients. This is what they have chosen to do. They have authorized me to speak on their behalf with everybody here to make sure we're on the same page. But to be clear, that is always the client's decision. The client need not waive attorney-client privilege. The second point you brought up I thought was interesting too. And I will say this falls under the large folder of things I never learned in law school, things I learned on the fly, is that there is a demographic of people, and I wouldn't have thought about it initially, but if you think about it, it makes a lot of sense. There is a demographic of people who have a disproportionate number of changes compared to another demographic of people, and that is childless individuals. Okay, because what I'll tell you is that most people who have children, it's pretty much divided evenly among surviving children.
Makes it easy.
You know, there may be some charitable intent. There may be some gifts to grandchildren. There may be some, you know, my godchild or godchildren get this. But for the most part, it's just children. Okay. Whereas people who don't have children, the distribution's all over the place. You know,
Right.
it could be that. And I've had people say to me, you know, my nephew has not come to see me for the last 5 years. I want him out of the estate plan. It happens. So again, having the ability to be able to adjust the documents again becomes very important, because you don't have to worry about the price at my firm to do it, but also just the awareness to say, okay, life circumstances change. We want to be able to make sure the estate planning documents adjust accordingly.
That makes a lot of sense.
Yeah, because that is a group. And again, I never would have thought of it, but it makes a lot of sense in terms of why those people would be more mercurial in terms of whom they give money to and the amount of money they give money to, or even the reasons under which they decide to either alter or eliminate or add certain people.
So, throw a scenario at you. Husband and wife, they go in, they get an estate plan set up together. Wife passes, husband's still around.
Yep.
Husband decides after the fact that he doesn't like the way everything was allocated, everything. He changes all of it.
Right.
Perfectly legal, perfectly fine, able to be done.
You bet. Absolutely. Unless the document, and I will ask that, especially in the cases of blended families, do we want surviving spouse to be able to alter the distribution? And that's up to them, right? Now, I'm assuming that these people do not have a prenuptial agreement or even a postnuptial agreement, because if they do, that's going to govern, right?
Right.
But assuming they don't, then that's the question I'll ask. Do we want surviving spouse to have the ability to make those changes? Because the pro to that, of course, is life events occur. We want surviving spouse to be able to make changes. The
Right.
con to it, I call it the Brady Bunch example, right? You know, and again, that show predates me quite a bit. Bear with me here, but I know vaguely about it, right?
Right.
Wife comes in with 3 daughters. Husband comes in with 3 sons. One of them predeceases. Could they rewrite their estate plan to eliminate the deceased spouse's children? Absolutely, they could. But we could draft it in such a way that they can't. But there's pros and cons either way, and that's what I will walk my clients with blended families through to make sure they understand the ramifications of that.
Is there a way to lock in certain things and make other things flexible?
Yeah, that's the thing. I mean, you can specify certain things, but again, we do have to worry about Wisconsin marital property laws there too, so those do come into play. But yeah, it's not an all or nothing proposition. It could be some things, and one of the common ones is the ability to reside in the home. What'll happen is it'll be a second marriage for each, and you know, wife owns the home that husband lives in. Well, wife dies tomorrow. What do we do with the home? Are we kicking husband out that next day? Probably not.
Right.
But do we want to give husband time to be able to move out? Do we want to give him the ability to live there the rest of his life? But then that question becomes, well, then who pays for repairs? Because it's going to her kids under this hypothetical. If the roof goes out, who's paying for that? So there's things we have to walk through and then draft the documents to reflect the preferences. Absolutely.
So this obviously tells me that when people come in and sit down with you, or if you're sitting across the dinner table with them talking about
Sure.
stuff, it really behooves them to come to you with everything. I mean,
Right.
they got to kind of like, I'm not going to hide the fact that I've got a side property or an
Yeah.
extra house or whatever.
Right. And I try to elicit that information from them as well. And I try to ask questions that get at, is that the only property either of you has an ownership interest in? Is this a second marriage? Whatever the case is. And again, most people aren't going to lie to their lawyer,
Right.
Generally speaking.
Hope so.
So I try to, and again, yes, candor is obviously a good thing, but I try to get as much of that on the table as possible.
Have you had instances where people come back to you 2 weeks later, a month later, whatever, and be like, we totally forgot we have this? Or,
Oh, yeah. No, absolutely. And then usually it's just a matter of updating the beneficiary. But if it's real estate, we have to create a new deed. I don't think I've ever had a client tell me they forgot that they owned real estate. I don't think that's happened before. I did have one client who wasn't sure how the real estate was owned. In other words, he knew he owned it with some family members.
Right.
Then I had to pull the deed to figure out, what percent he owns and that kind of stuff. But I've never had anybody affirmatively forget that they owned real estate. Bank accounts happens all the time. People just realize, I set up that CD 20 years ago and there's still 10 grand in it. I've had that happen before, but that's an easy fix. Go to that bank and list your trust as beneficiary. Done. I don't need to do anything from a draftsmanship standpoint. So it just depends on the nature of the find, so to speak.
And of course, if anything like that comes up, you definitely want to reach out, because it might be something where you directly say, yes, we got to make a change, or nope, this is covered under the wording and the provisions that we've put in place.
That's exactly right.
I like how simple and easy you make it.
I try.
It sounds complicated, and obviously on the back end, the legal side of things, it is very complicated.
Right.
But as you've said so many times, you draft these specifically in a way because you want to avoid that 12 to 18 months of probate. And that's your goal, is you want to guarantee no probate for people who come see you.
That's right. And again, like I think you hit it on the head. How I explain it to people and how it actually works behind the scenes are two very different things. We get to the same outcome, but again, I don't see the point of talking over people and explaining in unnecessary detail. I pride myself on being able to speak fluent English and legalese. And I know most of my clients don't speak legalese, so I speak English to them.
I imagine if you put one of your legal documents in front of me, I would stare at it and go cross-eyed. But the way you explain everything to me definitely makes sense, and I'm sure our listeners out there will agree. We are reaching the end of the show, so I'd like you to take another moment to remind people, how do they find you online, calls, wherever you're located?
Yeah, so the best way to get a hold of me is by phone. My office number for all 4 of my locations is exactly the same, 262-347-3444. Again, 262-347-3444. Main office for listeners and viewers is in Beaver Dam. I use Sandy and Matt Heyer's office. My main office is in Saukville, which is about an hour and 10 minutes due east of here. But I also have offices in West Bend and Germantown. Free initial consultation available at any of those offices, at your home, by phone, by Zoom, and then 20% discount for WBEV listeners and Daily Dodge viewers.
Awesome. Well, as always, Rob, great having you on. Look forward to having you on again soon. And I want to remind everybody that was watching, this was a paid program. The advice and opinions expressed during the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.
to 1430 ESPN Beaver Dam, WBEVAM, Beaver Dam, Dodge County, a locally owned Good Karma brand station.
It's time for the Damn Sports Show, presented by Real Sports Cards in Waupun, featuring Mr. Smooth himself,
My who's hot is Wally. Yeah, that's fair. Smoking hot.
Corey Sparks, and a real athlete,
I am an athlete. I am going to show up and dominate.
Wally Lukaczynski, covering everything Titletown and pro, college, and high school sports around South Central Wisconsin. Here are these heroes, really heroes?
Just proving the hero that I am, just in the nick of time to be tortured for all of your enjoyments at home.
Okay, here are these heroes now. Broadcasting live on 1430 ESPN Beaver Dam, Daily Dodge TV, and the ESPN Wisconsin app.
Hello and happy Monday, everybody. We are back in studio. We had a great week at the Dodge County Fair, the 172nd edition of the Dodge County Fair over at Good Karma Brands Park. Lots of great fans, partners, and teammates there. Of course, the stage brought to you by our friends at Newman Pools. WDS Construction did a remarkable job of building that. It truly felt big time to be able to have the show on there for 3 days, the better part of 5 hours. We had a big 3-hour show on Wednesday. Kind of got to pull the Wilde and Tausch or KBN move there and have a long show, and that was a lot of fun. The weather was amazing. The food was amazing. The people there were amazing. But we're back in here in studio. Gabe Neitzel joins us in just a few moments. The Cubs and Brewers start a 5-game series. What do the crew need to do to put the Cubbies away once and for all in terms of the NL Central Division race? An overview of our first week of the high school sports season in the 2025-26 school year. We have 2 games in 2 days coming up on Thursday and Friday, and we wrap up today's edition of the Damn Sports Show with Who's Hot, Who's Not on 1430 ESPN Beaver Dam, Daily Dodge TV, and the ESPN Wisconsin app. I'm Corey Sparks. I'm joined in studio by Wally Lukaczynski. We have Aiden Voigt producing up in the 1430 ESPN Beaver Dam studios today. Wally, we are back indoors, but the fair was a lot of fun.
I'm still drying out from Saturday. I know we were out there. We got lucky because we had all of our shows Wednesday through Friday. It was all dry, beautiful weather. Thankfully, most of our live content on Saturday was out of the rain. But even so, when you had those 2 squalls that just came flying through, we were still drying out a little bit. So had a blast. Can't wait to talk about Frozen Tundra Wrestling at some point during the show, too. They were a hoot. Can't wait to hopefully bring them back for a 3rd time. But perfect week, a perfect way to kind of send summer out the right way. And now I guess it really doesn't feel like summer's ending because usually it feels like baseball's kind of wrapping up. We're going into football right now. It feels like Brewers fever is at a fever pitch that we've never seen before. So we had not a standing ovation, but we had like people clapping yesterday when the Reds walked the Brewers off, not because they're happy about the Brewers' loss, but because of how proud they are of what this team's doing right now. And it was a really cool thing to be able to sit there and see. So I'm fired up to continue covering this Brewers team down this last couple months of the season.
100% agree. They just got in front of the Cubs 7-0 and finalized that game mere moments ago. It's the first of a 5-game series. As I just said, we are going to get Gabe Neitzel on the phones. We're fighting through a couple technical difficulties, but we will get there. A reminder, you can follow us on Facebook at ESPN Beaver Dam, on X at ESPN BD, Twitter at ESPN Beaver Dam as well. We're fastly growing there. Our great new teammate and Ashley Dobrzinski's been putting 1, 2, 3 videos out a day, so you can get a new look at not only the show, but different polls and interviews around the fair, around the office. Great time to be had there. But you can follow us on all social media platforms. Your way into the show is 920-887-9595. Our poll question today on ESPN BD on Twitter, or X, whatever you'd like to call it, is how many games do the Brewers need to take out of this 5-game series? They've already checked off 1 box, the first end of a doubleheader. The second game should be underway in a couple of hours, weather permitting. How many games out of 5 do the Brewers need to take to truly put the division out of reach, if it isn't already out of reach? I think that's a valid argument to have as well, in that the deficit is back up to 9 games with just under 40 to go on the season. Here's what we'll do. We'll kick off our discussion on the Brewers putting the Cubs away, what they need to do that if it has not been done already. We'll do that right now. The Cubs-Brewers 5-game stretch began earlier today. It was a 120 first pitch. Again, that one just wrapped up. What does Milwaukee have to do to snatch Chicago's soul? That's what Hunter Vaughn of our ESPN Madison crew likes to say. Or what does Chicago conversely need to do to keep their division title hopes alive? Aiden, our producer, I know your hands are full right now. If you can hear me, could we actually get the audio up from David Kaplan? He joined the Saturday Scramble on 100.5 ESPN Madison. When I asked him what the Brewers or Cubs have to do to end this division, he said this.
Cap, there's a 5-game divisional series at Wrigley Field that starts on Monday. How many games do the Cubs need to take to give you any hope that the division isn't already won? Or conversely, how many games would the Brewers need to win to put this thing out of reach with the deficit at 9 games already?
5-game series, Cubs need to win 11 for me to have any chance of feeling good.
That's good.
No, this division race is over.
So that was a great answer. Surreal moment. I grew up like watching Cap, like on the Comcast Sports Network, which is not really much of a thing anymore. They used to do post game for Cubs games, and he would be their one. And his amazing, outrageous, flamboyant reactions were some of my favorites. So that was cool. But yeah, they need to take 11 of 5. So you probably need to win the first game to accomplish a numerically impossible feat. And they did not do that. The 8th inning was the big one here. 4th spot in the 8th. It was 3-0. And against that Milwaukee Brewers pitching staff, a 3-run deficit going into the 7th or 8th probably isn't a recipe for success to begin. But some walks, some lack of command. Joey Ortiz pushed one through the right side of the infield. And just like that, like they've done all year long, Wally, Milwaukee just nickels and dimes their way away. 7 runs on 9 hits, and Murphy ball. No errors once again.
I mean, they just don't let off the gas. It doesn't matter if they're leading. It's just always they want more when they're on offense. And I couldn't believe this. I was digging through the Brewers' 14-game winning streak. They trailed in over half of those games. If you trail in 8 games in a 14-game stretch, you don't win 14 games. And some of those comebacks, we're talking about 4 or 5, 7 runs at one point against the Reds. They came back and overcame. Even in the loss that they had on Sunday, they were trailing in the 9th inning and hit a go-ahead home run, and you just were sitting there like, this team is inevitable. They keep finding ways to win. It doesn't matter who they're playing. It doesn't matter how much they're down. There's no quit, and this team doesn't take any plays off. Nothing's for granted. It was kind of ironic that it was an error that cost the Brewers because they have been playing so clean. That error in the 9th inning yesterday against the Reds was the undoing of the winning streak. And it's going to take mental mistakes like that to actually see this Brewers team fall off. So to answer your question, you're asking me, 5-game stretch, what do the Cubs have to do to stay alive and keep this up? I think the Cubs realistically have to win 4 out of 5.
Yeah, so it'd be backs against the wall at this point. I think my answer would be if the Brewers were to put the Cubs away, what do the Brewers have to do to put the Cubs away in this 5-game series that has already begun? I think 2 games in this series, if they take 2 out of the 5, that's a very low bar. It means the Cubs over a 5-game series where it's really their last big chance to gain any traction would gain 1 game. So then they would be 7 games behind. That's still nearly insurmountable with under 40 games to go. This is over if the Brewers win 1 more game in this series at this point, with them winning the first game 7-0. The 14-game win streak is the longest in franchise history. And here's a little hypothetical for you. 38 games to go. If this team were to go 19-19 the rest of the way, they are a 97-win ball club.
Wow.
19-19 is severely cooling off compared to what the Brewers have done the last couple of months. The Cubs would conversely have to go 26-12 to get even close and tie them. That's if the Brewers hang around 500, which again would be a severe cool-off. That's not happening. It took the Reds extra innings and every bit of what they had and an uncharacteristic error to squeak out a win against this Brewers team over the weekend. This division and possibly even the National League is already won in my mind, and it belongs to the Milwaukee Brewers.
Uke Magic feels alive and well right now, and 19-19 getting you to 97 wins is crazy. That would be like a bookend weird season where, again, I feel like we've mentioned it on the show several times. They started 25-28. To start that far into the season, 53 games in, be 3 games under 500, and talking about a team that very realistically is going to be a 100-plus win team, that's just unheard of. With what they've done since the July 4th series, they've lost 5 games. They've lost 5 games in about a month and a half. That doesn't happen. They were trailing the Cubs at the start of that stretch, and now all of a sudden you're looking at a team that, if this series goes the right way, they might have a double-digit lead in their own division. That's just, it's video game stuff right now, and there's a reason why Brewers Fever is alive and well. It's just, to me, it's that question of, are you able to sustain that when the lights are bright? And it's a different kind of baseball. It's every pitcher hanging on to in October. If they're able to get through an NLDS, I'm going to be fully bought in that this year is the year they're coming out of the NL.
Yeah, I think this would be the year. I mean, you look around, there's the Phillies, there's the Dodgers, I was going to say the Mets. They've been falling out of the sky right now. I know the Phillies fans were originally worried about the Mets with Zach Wheeler going down. You might not have to worry about him, but I think David Kaplan making the comment of you have to take 11 of 5 perfectly encapsulates the crater that the Brewers have put the Cubs in. I mean, yeah, they're 79 and 45 right now, and actually my math was off earlier because the game has updated with the Brewers winning. So 79 and 45, the Cubs are 70 and 54. It's a 9-game deficit. So bottom line, the Cubs have to make up 9 games of ground in 38. And now, best case scenario, if they were to take the next 4, they're 5 back with 34 games to go. That's still a tall task. And again, you're asking a Brewers team that has forgotten how to lose baseball games to lose half of them the rest of the year. And then the Cubs, conversely, who have been a 500 team the last month plus, have to flip the script and essentially go on a Brewers-esque run. And again, if the Brewers continue to do what they're doing, I mean, that magic number is only going to drop as the time goes on. So that's, I think 2 games in this series, the best the Cubs could do at that point is gain a game when they had 5 opportunities to claw back and get into a deficit that looks pretty insurmountable right now. That's going to be tough. We are going to take an early break here and try and get Gabe Knights on as we battle through a couple of phone issues here. If we can't get him on, we will be recapping week 2 of the preseason as the Packers came out on top 23-19, basically won by a yard over the Indianapolis Colts. A lot of backups had action. I think the takeaways are going to be much brighter than what we saw in week 1 against the Jets. That's coming up on the other end of the break here on 1430 ESPN Beaver Dam and Daily Dodge TV.
Attention sports fans. Whether you're chasing the hottest rookie card, that next big autographed sports card, or looking for expert card services, Real Sports Cards is here for you. For everything from sports to Pokemon cards, visit the store in downtown Waupun today. Go to the Apple Store or Google Play and download the Real Sports Cards app for all the live online card breaks. Watch, collect, and win from anywhere. Real Sports Cards, where every day is opening day.
Looking for a new doctor? Prairie Ridge Health's family medicine team is welcoming new patients in Beaver Dam, Columbus, Marshall, and Sun Prairie. From wellness checks to managing chronic conditions, we are here to care for you at every age and every stage of life. Meet our providers and schedule an appointment at prairieridge.health or call 920-623-1200. Prairie Ridge Health, inspired by you.
Catch the Milwaukee baseball game this Sunday on 95.3 WBEV and listen for the Columbus Family Dental Mystery Player of the Game. Then tune in to the 95.3 WBEV morning show the following business day. Be the correct number caller when we ask who was the Columbus Family Dental Mystery Player of the Game. Get it right, and you'll win a pair of Milwaukee baseball tickets. Be sure to listen to 95.3 WBEV this Sunday for Milwaukee Baseball's Mystery Player of the Game, brought to you by Columbus Family Dental.
Gruber Law Offices. One call, that's all.
They treated me like family.
They're actually people that you can depend on.
They made me feel seen. They really treated me like I was a part of their family, a part of their team.
They ask how you're doing, how you're feeling.
They're just so welcoming and so sweet and kind.
It's like family, caring about another member of the family.
If you've been injured, it costs you nothing to see if Gruber Law Offices can help.
Choosing the right windows is key to your home's beauty, comfort, and efficiency. That's why Hometown Glass and Improvement features pinnacle windows from Lindsay. With sleek designs, cutting-edge energy efficiency, and a lifetime warranty, Pinnacle windows from Lindsay save you money and add value to your home. Plus, they meet Energy Star standards and are made in the USA. The Hometown Glass and Improvement team will guide you from consultation to installation. Visit the Hometown Glass and Improvement showroom in Beaver Dam or online at hometownglass.com.
Have the dog days of summer got you feeling hot, sweaty, and down? Then you need to call the expert team at JB Mechanical. When that summer heat hits hard, count on them to help you defeat it. Give a dog a bone and give yourself a much-needed break while the JB Mechanical team tackles any important AC services, from repairs to replacements, whole house dehumidifiers, and more. Learn more about their practical and cost-effective solutions by visiting jbmechllc.com. JB Mechanical is a proud dealer of Train equipment.
Nothing runs like a train.
McKinstry's Home Furnishings in downtown Beaver Dam believes that everyone who labors has made America strong, prosperous, and a great country. To celebrate Labor Day, McKinstry's is having a store-wide sale. McKinstry's Home Furnishings showroom is filled with sofas, reclining sofas, sectionals, and chairs at unbeatable savings, like Lazy Boy recliners starting at $349 and love seats starting at $699. Also save big on Simmons Beauty Rest and Symbol mattresses. Dining room and bedroom sets are also marked down for this event. Add the finishing touches to your home with pictures, area rugs, and accessories. McKinstry's offers you all the latest styles, always designed to fill your home with comfort and quality. Hurry in now and discover the Labor Day savings at McKinstry's Home Furnishings in downtown Beaver Dam. Sale ends Saturday, August 30th. McKinstry's will be closed on Monday, September 1st to celebrate Labor Day.
Sometimes they have no idea what they're saying out loud. Isn't that what local sports talk is all about? Hear more shenanigans now on 1430